SJC-13193, City of Lynn, v. Ariana, Murrell.
Okay, Attorney Jens, or is it Gens? I'm sorry.
It is Gens.
Okay.
Good morning, Your Honors. May it please the court. There are three issues contained in this appeal. The first one, I think, doesn't merit much discussion at this point in time, and that is the issue of mootness. At one point in time, the mask mandate from the governor had been rescinded or expired when the governor ceased his enactment of the his powers under the Civil Defense Act. However, since that time, as we predicted in our brief, the City of Lynn is, of course, now imposed its own mask order that does essentially the same thing. There are flaws with that too, in terms of the fact that the mayor.
Well, counsel, can I ask you a question? Is the issue of Lynn doing it properly before us? Has that been brought in any of the lower courts?
No, it hasn't, Your Honor. But in terms of mootness, I think that if the court were to determine that this matter is moot just because the governor's order is gone, the same controversy arises, but under the mayor's order, and that has the further.
As I remember from reading all that law in this area, it seems to me there's a strong argument to be made that the individual municipalities have actually more power than the governor to do things like that. Isn't that right?
I would disagree with that because the governor at least had the authority of the Civil Defense Act as determined by this court in the Desroisers case. No such legislative enactment provides the mayor or the local public health authorities with that type of authority. I realize there is an argument that they have the broad authority under the public health statutes, but certainly it wouldn't be enough to enact the type of comprehensive regulatory scheme that the governor did, that included things like the mask orders and declaring some businesses essential and others non-essential.
So you're basically, your point is, look, even if this is moot for the governor, it's still happening in the municipalities.
Precisely my point.
But we're not briefed on the municipalities, are we?
Well, you are, insofar as the municipalities, would be potentially preempted by federal law by doing the same thing. That argument would still apply. And two, the other issue in the case, besides the mootness and the preemption, is what type of showing does the government have to make to obtain a preliminary injunction? And of course, our argument is they fell short of the very modest showing that they have to make. And of course, that's the other, those are the two issues that I'd like to discuss with you. But I think that from a mootness point of view, we're faced with those issues even under a mayoral or a public health type of order, both the preemption and the standard for the issuance.
I don't understand that though, because we don't have, OSHA is sort of uncertain too because of the US Supreme Court's decision. So this case was decided before there was any regulation by OSHA. Then the US Supreme Court guts part of the regulation by OSHA. So that's uncertain. The governor has withdrawn his regulation, or it's not in effect. And we don't really have the legal argument on the municipal stuff. So should we really be deciding this case?
Well, if a municipality does the same thing the governor does, the same federal preemption analysis, and you rightly point out some of the uncertainties in it, would still be applicable. We'd still have to sort that out. And certainly, if this court were to declare this case moot, we would be, and my client were to conduct her business in the way that she has in the past, we'd be right back in the courts again with the same issues on the federal preemption.
Mr. Jess, is your argument regarding preemption is it's capable of repetition, and indeed it has repeated itself and may escape review if we don't look at it. That's your bottom line on mootness?
That's essentially it, although I'd go further and say it's right back at us, although it's coming from a different sovereign.
Can I ask just, is there still an open question about fines that your client has? I mean, does that impact the mootness question?
I think that it certainly does, that is going to have to be sorted out. And this court's determination of that would almost inevitably be
But
dispositive of that issue.
Isn't that in another case? That's not in this case, right?
Well,
a
that's
different
true,
case.
but it's true, but it is an issue that if this court were to determine it, would govern the other case. In other words, let's suppose that this court said there is federal preemption here, the governor's regulatory scheme exceeded its the supremacy clause, and it can't apply. Well, then the fines can't stand.
Yeah, but we shouldn't decide this case so that we can help resolve the matter in the Lynn District Court. The issue is we have an issue of constitutional dimension, and we could have all different types of permeations as it relates to masks and other issues with the pandemic. So I go back to Justice Kafka's point, where the mandate's no longer in effect at this very moment. Why do we want to tread into these waters and perhaps create a conceptual framework that doesn't meet the next iteration?
Well, the possibility of this recurring in much the same way is certainly there. We have seen time and time again governments reverse course and then reverse course again. It's been 2 years now, and there doesn't appear to be any coherent end in sight. And I think that the lower courts and the governments and the citizenry could use some guidance as to whether or not this area of workplace regulation is preempted or not. And I'd like to make a few arguments along those lines, which I think are significant and bear upon the mootness issue as well, because they're once again capable of and likely to recur, just as this mask mandate recurred as we predicted, even though it didn't come from the governor, at least at this time around.
But can I ask you before you go into preemption? I'm sorry, I know you really want to dive into it, but my question on mootness is the following. Capable of repetition is only one half of the test we used on mootness. The other half is yet evading review. And where you have a pending cease and desist order and an appeal, is this really something that will evade review? I guess it goes to Justice Lowy's question, you know, why are we going to help the Lynn District Court in this way when it's perfectly capable of addressing the issue before us?
Well, the Lynn District Court is just addressing the citation issue.
And is your defense in the citation issue that the governor did not have the authority to issue these orders because they're preempted? Is that your defense? Or
That's part of the defense. Yes.
Or so you have a different defense. So even further to the point of mootness, that case might be resolved on whatever other defense you may be suggesting in that case.
It's possible.
Okay. All right, well, why don't you go ahead on preemption? You know, unless somebody else has questions on mootness.
Okay, well, I would like to go ahead on preemption, although I'll concede to you that that is not the issue that interests me the most. The issue that interests me the most is the absence, the paucity of any showing by the government to support this claim that the public interest will be harmed in the absence of the injunction. And but I'll deal.
I realize that you're not interested maybe in the preemption question. I personally am, so I'll ask you my question.
I didn't say I'm not interested. I'm just saying not my priority.
Okay, well, let me ask my question anyway. How do rules and standards regarding face coverings to mitigate this novel coronavirus in public places, including places where the public is an invitee, conflict with OSHA?
Okay. The two arguments that the court below and the government, both the Attorney General and the City of Lynn, have made why OSHA doesn't apply. I'd like to just address it from that angle. First of all, OSHA does, they claim that OSHA doesn't have regulations or enforcement dealing with COVID-19. That is contradicted right in the court's decision, page 6 of the memorandum decision that's in the addendum, where the court is quoting from OSHA and states, and this is a direct quote.
Are you
This is a
going to
direct
read to
quote.
us from the guidance that OSHA has given in the relevant time frame?
I'm sorry, I didn't quite hear or understand what you asked me.
Well, there's a difference between rules and standards promulgated by OSHA, as I understand it, and guidance that OSHA might issue.
Okay, well, OSHA, I think we can agree OSHA issued guidance, but rules and standards, they have an enforcement action on this very point against this very party. And the court, quoting from them, stated that there was violations for liberty failing to, quote, furnish employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious harm to employees, and that employees are working in close proximity to each other and customers and are exposed to SARS-CoV-2, the virus that causes COVID-19. So obviously, OSHA.
My question to you is, I understand it, and I haven't pulled the cases yet. My understanding is that guidance that OSHA might issue does not have the preemptive status that a rule or standard that OSHA issues. And so my question to you is, what is your response to that argument?
I would agree with the point that mere guidance alone wouldn't suffice. However, enforcement of OSHA standards, which is happening in this case, and which I'm quoting from, would constitute OSHA's involvement in this area of workplace safety.
Is OSHA directed at employee health and safety as opposed to public health and safety for the customers that go into Liberty?
I think that OSHA's could potentially flow, even though their primary responsibility is worker safety or workplace safety, to the extent that the public is present. I think that there are OSHA standards, things like hard hats on job sites and things like that, that would be directed towards the public insofar as the public is involved in a workplace.
How?
Because it would compel the public to conform to the OSHA requirements as long as they're at the workplace.
But here we're talking about a regulation that you obviously dispute, but a regulation that says is airborne disease. We're going to protect the people that walk into Liberty, the customers. And OSHA says, to the extent there's some guidance, but OSHA says you have to mask up to protect each other.
Well, OSHA doesn't.
There are no airtight containers. We still have safety rules that the state imposes: traffic safety, building code safety, and OSHA says you need compliant ladders. But the state has safety rules in job sites, building codes, right?
Yes, they do. And I think that the Steel Institute case is extremely instructive for us in determining this case here. In that case there, it involved cranes and things like that. They were basically potentially endangering the public if they fell over. But the state regulated them under the building codes. It was found not to be preemptive of OSHA, but the salient feature of that case is they didn't regulate cranes or any of that equipment on private work sites where the public wasn't, whereas the governor's scheme does. In other words, the governor's scheme doesn't regulate private activity. If I come over to your house or to your backyard, we have a barbecue or something, I don't have to wear a mask.
Let me ask
Well,
you
I
this.
sort of want to, I try not to ask this question, but I guess I have to ask it as it perhaps relates to the public interest. What's the thought process behind having people come into the business and have their masks confiscated?
The thought process there was that the masks were harmful. And there's evidence in the record going to that point. Obviously, in the absence of a enforceable rule from the governor, if the governor's mandate is somehow unlawful, an employer would be well warranted in taking a position that the masks are harmful. They're giving off chemical vapors and the like. And that was a position that my client took after doing research and after observing ill effects in the workplace from the masks.
Let me ask you a different question. I hadn't finished the question I want to ask you is, I walk into Liberty to get my taxes done off the street, and I'm not wearing a mask. Can OSHA fine me?
No, I don't think that they could.
Okay.
But consider this, in the back room or the warehouse of a business, 2 employees under the governor's scheme would have to wear masks. In their backyard, they wouldn't. So the governor's scheme is actually more directed, and I could cite many other examples, more towards the workplace than it is towards the public. So this idea that the workplace regulation of the governor is incidental to protecting the public really falls, once you examine this entire scheme of the governor, which is, to my mind, as a business litigator primarily, a vast business regulation scheme. In our addendum, there's the governor's order number 33, which was not the mask order, but it is basically the overview of the workplace safety rules. And it's just replete with all sorts of workplace safety things that don't apply in many or most instances to the public at large, and they're going about their private business. So that's a terrible problem in a preemption type of analysis. And I think that Steel Institute case where the government is wisely and consciously exempting workplace activities where they're not interacting with the public is the type of case that can survive a preemption challenge, whereas this one here is highly problematic. And once again,
Attorney Gens, I'm gonna ask if anyone has any further questions. Okay, thank you very much. And we're gonna move on to Attorney Wellock.
okay.
Am I saying that right?
Yes, Madam Justice, it's Attorney James Wellock.
Great.
Good morning, Chief Justice and Associate Justices, and may it please the court. My name is James Wellock, and I'm the Assistant City Solicitor for the City of Lynn. I'm here representing our Board of Health. This case is before you on your own motion following a justice of the Superior Court issuing an injunction to enforce the cease and desist order of the local Board of Health, coupled with a stay order, as he certified 2 questions to the appeals court. First, whether the OSHA Act, a federal statute, preempts the governor's executive orders to address COVID-19, and 2, whether the court correctly found issuing an injunction was in the public interest. But before we get to those questions, excuse me, before we answer those questions, this case is moot. COVID-19 continues to affect how we all live, work, and play. I'm making my big SJC debut today, appearance today by Zoom for this very reason. But the legal landscape that existed when the board brought this suit no longer exists.
How do you distinguish the SCOTUS Archdiocese case?
I'm sorry?
How do you distinguish the Supreme Court's Archdiocese of Brooklyn case?
I'm unfamiliar with the Archdiocese of Brooklyn case. Mr.
Okay.
Justice.
All right, maybe the AG will answer that as well. Thank you.
The governor's orders that the board wished to compel compliance have all been rescinded. And there is no relief that this court can grant to either the board or Ms. Murrell. There's no live controversy here. Even if this court were to sustain the ruling of the Superior Court, Ms. Murrell's business would continue to operate as it currently does today because the orders are over. There's no live controversy. To the preemption question,
Before you move on, can I just ask about the question about addressing it because this is an issue that's capable of repetition yet evading review? What's your response to that?
Well, there was an avenue for review by the appellant. The appellant could have brought the Board of Health to court to challenge the cease and desist order. It didn't. The cease and desist order was ignored and was not complied with, was not appealed. So the city sought an injunction against the business, and the appellant did not file a affirmative defense or a counterclaim against the board challenging the order. So as far as evading review, it seems to me that the legal challenges to the board's actions, there was an opportunity there that was missed. And so I think that those arguments in this case anyway are waived. But there's also a number of other avenues to review this particular matter. The lawsuit at the district court, which has been mentioned, and there was also an injunction issued by the State Department of Labor Standards, which I believe is also being challenged in a Superior Court case. Should further litigation occur in the future, I don't see how we can, at this point anyway, speculate and say that those future instances of enforcement could evade review as well.
Isn't this a little complicated though? Because Lynn's mask order didn't go down with the governor's regulation. It's ongoing. So this is a little different because there is a live controversy. We just don't have the issues briefed in this case. And we also, the preemption issues are, you know, we're dealing with pre-OSHA activity and pre-US Supreme Court decision on that activity. So it's kind of, it's all conjectural. But we do have something that's alive, which is the Lynn's mask order, right? It hasn't taken it down yet. Normally when we have something moot, we have the whole thing's moot. This is a little odd.
So the Superior Court action had nothing to do with Lynn's mask order. Lynn's mask order was issued in December of last year. This case was from, I think, almost a whole year ago, back in the early spring of 2021. So the substance of the Superior Court case had nothing to do with the Lynn mask order.
Right, but the justification, I understand the justification has disappeared. Lynn was acting under the governor's authorization. Now it's acting under its own authorization. It's just, it's not, this is a little different from cases where there's not a live controversy. There's a live controversy. We just haven't briefed the right issues, it seems like.
Well, I understand that there is a mask order in place, and so the substance of what has been requested for enforcement exists, but it's not properly before this court. If I could continue to preemption, as was rightly stated by a justice of this court, there was no OSHA standard in effect at the time of this lawsuit. There was guidance, but guidance is not a standard. And in order to show preemption, there has to be a hard controversy between a federal standard and the state requirements. We don't have that here. It simply did not exist. And that's evidenced by, in the verified complaint, OSHA was actually present at the the defendant's property and issued a citation not under citing any OSHA standard, but citing a general, this business is unsafe to the public welfare, specifically because it's not following the local requirements, meaning the state mask mandate and the DLS regulations. Onto the public
I'd
interest.
ask you to address opposing counsel's argument that that last bit, that OSHA is enforcing its guidance, shows that there is preemption.
Well, so I don't believe that it enforced its guidance. I think that the citation is very clear in its stating that it is issuing a fine because this business is operating in a dangerous way to the public by not following the governor's orders and the DLS regulations. It was not enforcing, and it does not say that it was enforcing the guidance.
So we have a federal agency enforcing a state provision, and you're saying that there's no preemption. Can you just tease that out for me, because it seems a little inconsistent.
It's a sticky situation, but I think that what OSHA was trying to do was, and I think it was properly recognizing that there was a very dangerous situation, that COVID-19 presented an immediate danger to the public.
Well, yeah, I mean, besides the sort of the details and the facts and all that, how is it that a federal agency enforcing a state guideline doesn't sort of implicate this preemption issue? I understand the nature of the threats and the state, but it seems to me that there's a federal agency enforcing a state guideline or rule, issuing fines in connection therefore. Suggests maybe OSHA thinks it's occupying this field in some way.
Well, I think that OSHA's fine was based on the fact that the business is being operated in that dangerous way. And I think that what they were doing was not enforcing the guidance or a particular standard, but rather we're just enforcing the OSHA Act of 1970, Section 5A1, which requires that businesses not act basically recklessly and intentionally or willfully putting their employees in a known danger.
So how does Section 5A1 not preempt the mandates here?
Well, I think that they work hand in hand. It does not directly conflict with the state guidance, but instead is built on it. And the state orders provide instruction on how to operate a business safely. And compliance with those orders would allow these businesses to operate in a way that was safe for the public and for those employees.
Any other questions? Okay, thank you.
Thank you, Madam Justice.
Attorney Parr.
Good morning, Chief Justice Budd, Associate Justices. May it please the court, Kim Parr for the Commonwealth. If I may go back to some of the open questions that have been asked of my brothers. First off, the fact that the city of Lynn still has an active mask mandate really has no bearing on this case. If you go back to the cease and desist order, the city was proceeding solely under the governor's emergency orders. That's at Record Appendix 63. Also, the mere fact that a mask mandate exists in the city of Lynn does not justify reaching out to tackle that issue. I did not hear Attorney Gens even suggesting that there was an enforcement action against Ms. Murrell or anyone in the city of Lynn. So to the extent this question of how OSHA may preempt a municipal face mask is meant to come to this court, it should come through an active dispute between parties who were sanctioned under that particular order. That's just simply not what's at issue in this case. As for the status of the fine cases and the status of the fines, yes, that there are two cases actively going on. One is the 40U matter in district court, in which Ms. Murrell is challenging the city of Lynn's fines under the cease and desist order. As the record appendix shows, and Attorney Gens said today, the OSHA preemption question is active in that case. There's also a 30A action for judicial review of the Department of Labor Standards final decision affirming DLS's own cease and desist order. And that Ms. Murrell also raised OSHA preemption when noticing that appeal. So on the question of whether this issue is capable of repetition or evading review, those two actions show that it likely won't evade review and very well could come to this court through those other avenues where the parties still have a very real personal stake in the matter. I also would add that OSHA preemption cases are not typically so transitory in nature that they never reach this court. They got to the court in Chadwick, and in another case, Commonwealth versus College Painters, I believe is the caption. The court also has reached many COVID, the constitutionality or validity of many COVID orders before those were rescinded, just like in DeRozier's. Would the court like me to speak at all about capable of repetition?
Could you address the Supreme Court case if you're familiar with it?
Do you mean Roman Catholic Diocese? That's readily distinguishable because by the time that got to the Supreme Court, New York state of emergency and the applicable COVID orders were still in place. There was only a question about where the governor was moving houses of worship between, I think, like a red or an orange zone. And so there really was a risk that the governor still had this authority in New York and could change the designation of houses of worship at any time before or after publication. Here, in contrast, the state of emergency has been rescinded. The applicable COVID orders are gone. And so you would have to take many more leaps of, not quite logic, but you'd have to speculate about the governor again triggering the Civil Defense Act.
Well, were we teetering on that with Omicron? I mean, I guess that's the issue, is whether or not the governor could, if there's now we have an Omicron 2 variant, right? And we're not out of Greek letters. So can't this come back?
I think if you look at how the administration has handled Omicron, it really speaks volumes about the likelihood of the Commonwealth returning to the lockdown status of early 2021. And it suggests it's very unlikely because even in the wake of this tremendous surge over the winter, the governor did not fall back on the Civil Defense Act and did not issue any sort of statewide mask mandates. Instead, the administration proceeded under a much narrower emergency declaration under the Public Health Act. To take action under that, the Commissioner of Public Health needs approval of the Public Health Council. And even under that process, there's still no statewide mask mandate. It's been very targeted to specific industries, to vaccines and testing. And so, no, I don't think it's actually likely or certain, or at least likely that this exact set of facts will happen again. And actually the First Circuit, looking at the same time period and fact pattern, found that it would be, quote, unrealistically speculative to think that we would fall back on a statewide.
To what extent do we factor in the city of Lynn's own mask mandate that continues to be imposed?
In a way, I think that shows how decentralized the Commonwealth's response to the pandemic has become, where the governor has not issued something at the statewide level, municipalities are free to act. And so the fact that the city has issued a statewide mask mandate, as I said earlier, there could be a possibility that a preemption challenge arises in that respect, but that's not the case before the court right now. The case before the court right now is a declaratory judgment action about a cease and desist order that can no longer be enforced because the premise for it no longer exists, or the justification for it no longer exists.
So we're gonna have to wait for the case to be brought against the city of Lynn on preemption, and then we're gonna have to decide this later? Is that what you're saying?
To the extent Attorney Gens was encouraging the court to reach the question of municipal preemption, yes, because that is just not the dispute between the in front of the court right now, or between these parties at the moment.
There also the issue of OSHA moving on, having issued actually its own set of guidelines that have been rejected by the Supreme Court. That case still pending. There's a lot of moving parts. Isn't that true?
There is. And when you're looking at preemption, what you're doing is comparing what the state has done to what the federal government has done. So in evaluating this question of whether or not the dispute is capable of repetition, the court does have to consider both sides. And as the First Circuit has said, it's unrealistically speculative to think that the Commonwealth will fall back into this lockdown situation. But to your point, Your Honor, it's equally speculative to think that the legal landscape of preemption would be the same, where so much has changed on the OSHA front. To your Honor's question about enforcement and preemption, I would point you toward Kansas versus Garcia, Good versus Altria Group. They're both cited in our brief, and they stand for the proposition that preemption concerns authority written in the constitutional text, federal statutes, or regulations. So an enforcement action is not enough to trigger preemption. You have to look at what OSHA was proceeding under. Here, OSHA only proceeded under the general duty clause, and the Commonwealth isn't aware of any court that has given preemptive effect to the general duty clause. In fact, the three cases we cited in our brief from the First Circuit, the 10th Circuit, and I believe the Western District of Washington have all found that it should not be given preemptive force. And that tracks with the language of the OSHA Act and the teachings of Gade, which is that Congress expressly said in the OSHA Act that only federal standards should displace state authority. And so the fact that OSHA, that Congress included a general duty clause without also giving it preemptive effect strongly suggests and presupposes that the general duty clause should not displace state law absent a federal standard.